And today we have another interesting topic to look at, like the Nigerian Police Force Established Act 2020 implications on human rights. That is the topic of discussion for today. And to discuss this, we have OLAITAN EYIOWUAWI, consultant solicitor, Simeon Bethel Solicitors, London, United Kingdom. You're welcome, sir. We also have MAZI AFAM OSIGWE. He is a senior partner at Law Forte and former General Secretary, Nigerian Bar Association. You're welcome also. We also have KUNLE EDUN. He is a human rights activist, welfare secretary, Nigerian Bar Association, and senior partner, Tri-Lex Partners, LP, Warri, Delta State, Nigeria. You're welcome.
Thank you very much.
Finally, on our list, we've got Sylvester UDEMEZUE. He is legal practitioner and lecturer, Nigerian Law School.
Thank you very much. Without wasting time, I think we allow OLAITAN to kick off his presentation if you are ready to do that, sir.
Well, I didn't think it was going to be a presentation, but thank you very much. And I really appreciate the privilege of coming on to your live program. I think it's a very topical conversation at the moment, considering what's happening in Nigeria now, which is the big elephant in the room. And I will start off by saying that the current act, the 2020 Act of the Nigerian Police Act of 2020, it attempted to be an all-conquering statute regarding matters policing, and it's quite extensive in its provision. It was signed into law by the President on the 15th of September, though I didn't see anywhere on the act where it confirms when it comes into effect. So we'll assume that it came into effect on the day the President signed the bill, 15th September 2020, and it repealed the previous act of 2004. And particularly, this current act has got 17 parts, 142 sections. And if you compare that to the act it repealed, which had only 11 parts and 69 sections, it tells you that, well, it's quite ambitious in its effort to provide a good policing law for Nigeria. And it laid quite a number of rules. The 2004 Act had just 7 provisions regarding police powers. This current Act has got 40 different provisions on police powers. Like we all know, there are quite a lot of laws in Nigeria, a lot are on the book, never observed. People are not aware that they exist. The current provisions, the various provisions of this current Act are quite encompassing. But as we know, rules are observed more in breach than in compliance. As it relates to human rights, a lot will depend on how the lawyers actually seek to really push the boundaries of the law. Because looking at a particular section of this current act, Section 38, for instance, it gives police officers very wide discretions. And discretion, as you know, are the easiest thing to abuse, more so considering the nature of the Nigerian police force, which we know are not your friend. Policemen are meant to be your friend, but the ones in Nigeria are hardly your friends. So a lot will depend on legal practitioners in Nigeria to try and push the limits of the law by way of instituting litigation and leading them on to enforcement. And I also like to touch on a very, very important section of this current act, which mandates that every police division must have a police officer who must also be a legal practitioner. And the important thing about that is that this particular officer is a compliance person. And if you're a compliance person, you are subject to heavy regulation. And the police officer, being the compliance person in the police division, is regulated under the Legal Practitioners Act in Nigeria. And you can actually bring that person to book. If not under the Police Act, you can bring them to book under the Legal Practitioners Act. Then importantly, there are sections of the 2020 Act that I'd like to touch on, which are quite controversial. I'll look at Section 6, for instance. Section 6 is in direct conflict with Section 6 of the Police Service Commission Establishment Act. Under the Police Service Establishment Act, there is enforced a police service commission, which deals with different things from discipline to promotion. Then under this new act, that they established a new commission called the Nigerian Police Commission. And I think this is just consistent with how we tend to create bodies in Nigeria without regard to existing bodies. The highest decision-making body under this current act is the Nigerian Police Commission. And this commission has got 39 members. And these 39 members are the President of Nigeria, the 36 state governors, the IGP, and chairman of the Police Service Commission. You can imagine what these guys have on their table already. I do not think for the life of me that these 39 persons will have the time to really provide the management and the leadership expected of a police force to police about 200 million people. That for me, it's not something that was well thought of in this enactment. I will commend to the drafters to try and revert to the Police Service Commission, Section 6, which was quite considerable in its provision, in making allowance for women's interests, the Nigerian press, civil society, the judiciary to be part of the Police Service Commission that manages things this act tends to want to bring into play as well, discipline. And then one of the other things I also want to point out, which I think, talking about human rights law, the basis of human rights in Nigeria is Chapter 4 of the Constitution. And Section 5 of this 2020, the Police Act of 2020, now states that, well, the essence of this act is for the promotion and protection of human rights. Well, in attempting to do so, it also contradicted itself. One of such areas is the provision it made that private detectives can now be established in Nigeria, and detective schools can also be established, but it now subjected their existence to vetting and approval by the policemen. I think this is going too far. And I think it contravenes Section 16(1)(d) of the Constitution, as a sense that I don't think you need any license to be a private detective. Anyone can seek to dig up information subject to not infringing an existing law. Now, it seeks to now put people out for normal economic case to seek police approval to do what any normal person can do. These are one of the areas the current Police Act contravenes the Constitution. Then it's interesting also that there is also established a public complaints response unit, which is a very good development, really, in the sense that members of the public and anyone, including policemen, can send complaints to this particular unit. But sadly, this unit was not well constituted, in the sense that all its members are policemen. We'll have expected that a body to oversee police behavior and police conduct will have independent members, like retired judges, members of civil societies, and maybe journalists as well. Then the other area I want to really touch on will be particularly the use of police powers to infringe on rights of privacy. Now, coming back to Section 38, which provides wide powers to policemen to arrest without warrants and to detain and actually go into people's private properties, like, for instance, your phone. Your phone, smartphones today, we know it's more than just a phone. It contains a lot of information, which also includes your financial data, your personal data, your email addresses. The police having access to one's phone is a major breach of the right to privacy guaranteed by the Constitution. And coming back to what I said, it would depend on our lawyers to push the boundary of the law in letting the police know that, yes, you've got discretion, but your discretion must be subject to law. And this is where the police officer who is meant to be a legal practitioner becomes a very important person. Because two, one is a policeman, is also a lawyer. he can well impact the knowledge of the law on his fellow officers and tell them about the consequence of non-compliance. And also, as I said earlier, the legal practitioner, the LPA, which regulate lawyers, can also be brought to bear on, this legal person. So I'll let you go on to our next member of the panel before I come back to you.
Well, thank you very much for this brilliant presentation that's ably kicked off the discussion. Let's listen to MAZI AFAM OSIGWE this time. A senior lawyer in the bar. So let's see what he has to say about the new Police Act. MAZI, please.
Thank you. Let me start by saying that the Police Act 2020 is a poorly drafted and a poorly researched piece of legislation. And this may be due to no thanks to the fact that there was no proper consultation. First of all, the Act repeats so many things that are already contained in the Constitution. For example, Section 16 talks about creation of the Police Council. For goodness sake, the Police Council is already established by the Constitution, which also stated its composition and functions. And it makes no sense, therefore, for the Police Act to pretend to be setting up a body that has been set up and its functions set up and as contained in the third schedule, Article 29 of the Constitution. And then again, to also show the bad faith behind some of the provisions in the Police Act, you see the encroachment of the powers of the Police Service Commission in the Police Act by seeking to give powers of discipline and employment of the police force, taking it away from the Police Service Commission and giving them to the Inspector General of Police. And if you look at a number of functions, it seems as if the intention of the Act was to put so much powers on the person holding the office of the Inspector General of Police, not even in the Nigerian Police Force as an institution. You read for one of the sections that says the Inspector General of Police shall be reimbursed of expenses incurred in doing so and so. As if he spends from his personal pocket and the law now provides for him to be reimbursed. And then some of the sections are so poorly drafted that are vague. The interpretation of their provisions could give rise to a lot of ambiguity. Look at Section 66 that talks about bail. Look also at about Section 1 something or so that talks about that if a policeman has been acquitted of an offense, that shall no longer be tried. And to show the absurdity of that provision, I think it's Section 111, I'll get the correct section. That law goes on to say, but that he may be, that even though he has been acquitted, he could be disciplined, reduced in rank, or dismissed. How confusing can a piece of legislation be? Now, there are some provisions in that act that arguably could be said to be intended to enthrone police reform, respect for human rights. But you agree with me that in Nigeria, problem has never been the absence of laws. It's an issue of enforcement of provisions of law. Now, if you look at some of the issues arising from this NSAS thing, now where there are copious provisions made in the new Police Act about processing suspects who are brought into police station, you look at the issues emanating from NSAS, where protests, where there are revelations that no records of persons are arrested by SARS, and indeed so many other departments of police are kept. And I also think the Police Act makes nonsense of this requirement when it gives the police up to 48 hours within which to process a suspect. How can you bring a person to the police station and not process that person before taking him into custody? Get his name, get fingerprints, get every bio details about that person. And the law says they should do that within 48 hours. What about within the first 30 minutes of bringing that person to the police station? Some of the provisions seem to be intended to be self-defeating. What it gives in one hand, it takes away with another hand. There is need, if there had been proper consultation, detailed research, and removal of a self-serving objective of usurping the powers of Police Service Commission so as to empower the Inspector General of Police to recruit constables and some other police officers in the police, maybe would have had a better piece of legislation. Many people were not aware that an amendment was in the works, and suddenly a signed law was in circulation. And that is why you have the poor piece of legislation we have here. It could have been better drafted. It could have been better drafted and enacted to reflect the need to reform the police and have a police that is very friendly, that does not have that does not adopt opacity and lack of accountability. in carrying out his functions. I'll stop so far so that other people will make their own contributions.
Okay, we thank you very much, MAZI. We have KUNLE EDUN, please. We know you have a lot to say on this legislation. Are you able to make your presentation at this point?
Thank you very much. I think we just succeeded in wasting our time by going through and enacting this Nigeria Police Act 2020. It was an unnecessary legislation, like what my very good friend AFAM said, because many of the provisions of this said law are mostly repetitions of the provisions of the Administrative Criminal Justice Act, and of course the domesticated versions in various states, like in Delta states. Now, I want to pick one or two areas of this new law that I feel strongly that were actually brought in mischievously. Now, we are talking about, if we go to the provision of section 35(2), section 32 of the said law, it talks about when suspects can be investigated, arrested, and dealt with. That is the word that the law, this section mentioned. It said dealt with. How can you deal with a suspect? Are we seeing a military era? And by the way, it is wrong to itemize it that the procedure for dealing with a suspect is you start with investigation, then arrest. No, it is wrong. That is not the norm. The norm is when a suspect, when you feel strongly that a suspect has committed an offense, there's a reasonable ground for the person to have been arrested. You invite the suspect, you investigate thoroughly, and if there is a prima facie evidence that an offense has been committed, then you don't have a basis to arrest him. But that is not what the provision of section 32(1) of the Act is saying. So that section 32(1), it has now further come into legislate and give further approval to the procedure of the police, where they now do more of arrest-driven investigation instead of intelligence-driven investigation. And also, there is also, of course, one novel provision, which is not really novel, because also in the AJA and ACJ of various states, where the magistrate within some ministerial districts had the authority to now visit detention centers within their ministerial district. That is good, but it's nothing new. It is also in ACJ and ACJ of various states. And every month, a periodic report is expected to be produced after such visits. Now, there is a lacuna there. That provision talks more about knowing the number of detainees in such detention centers. What about properties that have been seized by the police? Because I was in court day for yesterday, on Friday. There was a case where policeman arrested somebody, and seized the person's vehicle. The vehicle had nothing in connection with the alleged offense. Now, the person was charged to court. The court made an order that the vehicle be produced. Therefore, I said I was in court, the vehicle was not produced. Should a magistrate not go to the detention center and the record shows that this person, my client, has been released, what about the vehicle that is still in the custody of the police? So that is very, very lacuna, because the police only talks more about detainees. It didn't mention anything about property seized. So it would have been good if property seized and still in the custody of the police are also itemized in the monthly report. Because we know as a fact that many of the vehicles that are seized, many of these policemen, they convert same to their personal use. And that is very, very criminal. Now, there's also this other aspect of the law that I am very, very worried about. The aspect talks more about the custody of detainees. We all know that the detention centers are smelling. They are dingy. No human being can actually live there for even 1 hour. The person will either faint or collapse or die. Now, the problem now is the Police Act now talks about recording of statements. The recording of statements in this wise, in that same dirty and dingy condition, it states that, of course, a relation of the suspect would have to be there. A relation or any person would have to be there. But it is not made in mandatory terms. And that is a problem. The same problem that AJA brought in, because AJA has not even helped. AJA made it optional. in fact, judicial decisions by various courts is that it is not even mandatory for a suspect lawyer to be present. I said, my lord, that is wrong, because the intention of the law is that before a suspect makes a statement, he must be availed the opportunity of having legal advice, and his counsel must be there. But the provision of the new Police Act has made it optional, which has not really changed anything. Now, further, we are also talking about the issue of, in fact, Section 44 of one of the 44 of the Act is a disaster. Why am I saying so? It made the requirement of visual and audio recording to be optional also. It shouldn't be. So, and let's ask ourselves, have we really moved away from the norm of collecting, extracting confessional statement from suspect accused person? No, because making the statement without the presence of your lawyer, making the statement with or without audio or visual aids, and that be made optional, not mandatory, certainly nothing new has happened. Nothing new has come in. So there is no innovation so far that I have seen in the Police Act. Of course, we are aware of a particular provision in the Police Act which states that suspects must not be arrested by proxy. Good, that is nothing new. The Constitution has already taken care of that. And of course, after that suspect also, when you are arresting a suspect, you must not base such arrest on the color of the suspect, the age of the suspect. You know, a lot of Yahoo boys have been arrested nowadays because of because of their hairdo, the way they dress. Of course, the Nigerian Police Act 2020 has taken care of that, that a person must not be arrested on such basis. But is that new? That is not new. The Constitution of the Federal Code of Nigeria, Chapter 4, has already taken care of all this. So the question now is, was there proper consultation? I believe there was none. I believe there was none. The NBA wasn't really aware of this. And I also know that experts in criminology and criminal law were also not consulted. That is why we are having a lot of issues with the new Police Act. But no matter how bad it is, I think we must also give the Police Act some kudos. Now, there is a novel provision in the Police Act which has to do with the creation of a group of persons. They call it special constables. Special constables. That is any person in the community, like I myself, for example, I can be recommended to be appointed as a special constable, and I think that is good. Of course, I will not be part of the regular police force, but for the purpose of oversighting the various policemen and their functions, probably going to the detention centers, special constables are now to be appointed. I think that is one innovation that, to the best of my knowledge, that AJA did not bring in. The Constitution did not really provide, but this new Police Act has made provision for it. So by and large, we can say very well that this new Police Act has not really said anything new, has not brought anything new to the table. And we believe that probably, particularly those sections I mentioned about taking of statements, visual aids, and audio aids when suspect statements have been taken, they ought to be made mandatory. But nevertheless, it is still left to the judiciary. I don't want to put all the blames at the doorstep of the police. Our courts need to be very, very active and proactive in the interpretation of these sections. I know very well of a case in Lagos that emanated from the Court of Appeal, where the Court of Appeal held that, notwithstanding the fact that May was used in that particular provision with regards to whether the suspect's lawyer or relation or any other person can be there when he's making a statement, that a collective reading of that provision indicates that it is mandatory. That is a proactive legislation. But I am afraid that most of the high courts have refused to follow that decision. They still strongly say it that no, it is optional, that it can never be mandatory. And in that very wise, we have a lot of persons that are in the detention right now, in the cells, in the prisons, that we are convicted solely on the basis of confessional statements. And this also creates a further problem for the police and the judiciary, and of course, the society at large. Because when you rely so much on confessional statements to convict an accused person or a defender, as the case may be, then you are preventing the police from interrogating the case very well, from going for further intelligence, for intelligence-driven investigation. That is what drives the world nowadays. That is what drives investigation. Intelligence. Thank God that SARS has been scrapped, because I keep on asking myself, if the police has been doing proper intelligence gathering, before the offense is even committed, they already know. They already know. So this the new Nigeria Police Act has not really made any difference, has not brought anything new that I've seen. And I think I agree with the previous speakers with regards to the position, particularly that of AFAM OSIGWE. I want to pause for now.
That's been a brilliant presentation. Thank you very much, Mr. KUNLE, for this elucidation. Well, let's invite our next speaker now, the last but definitely not the least, Mr. Sylvester UDEMEZUE, who is a lecturer at the Nigeria Law School, to speak on the subject. Mr. UDEMEZUE, you are welcome.
Thank you very much, my ogas, MAZI, AFAM OSIGWE, Mr. OLAITAN, and Mr. KUNLE EDU. I'm very happy to be here this evening to participate in this discussion. I hope you can hear me all.
Yes.
You can hear me here. So I'm happy to participate in this discussion. Because of want of time, I wouldn't like to go back to what has been discussed by my senior panelists. I would want to just raise one or two other issues in addition to the ones already discussed. I think I've pointed out this earlier, the provisions of section 32 of the Act, that because we're talking about how the Act has impacted on human rights. Now, if you look at section 32, section 66, sorry. So if you look at section 66 of that Act, which provides, if I may refer to that, the section actually says, there shall be assigned, section 66, subsection 3, section 66, subsection 3 of the Act, there shall be assigned to every police division at least one police officer who is qualified to practice as a legal practitioner in accordance with the Legal Practitioners Act, whose responsibility is to promote human rights compliance by officers of the division. Now, all my colleagues have spoken, each person harped so much on how poorly drafted and how very much the Act has gone into creating so many confusions. In fact, creating more problems than it has come to solve. Now, I will say two things about this particular provision. Number one is that it's a good provision because it has tried to, what it intended to do is to bring in a lawyer. A lawyer must be attached to every police station. And the duty of the lawyer is, or his responsibility is to take care of issues relating to human rights. In other words, his duty is to advise the police and ensure that every police station complies with aspects of provisions of human rights. In other words, everything that has to do with section chapter 4 of the Constitution. But the question now is, looking at this provision critically and reasonably, to what extent do we think that this policeman, this lawyer assigned to a police station will do this work? It is my opinion that this section, although an innovative one, would achieve very little. How? First and foremost, the lawyer you are posting to the police station is a policeman. So you are posting him there to go and monitor his colleagues. To what extent, just like Mr. OLAITAN pointed out, appointing a policeman, for example, to investigate a policeman, appointing a policeman to take care of complaints relating to a policeman. The commission or the body set up to look into issues of human rights violation and complaints against police officers, the body comprises wholly of police officers. To what extent do you think that the body will be able to decide that responsibility? So although I do not see that body, that complaints body, as a new body, because there had been X squad. The police X squad is a department in the police force, within the police force, that is in charge of all forms of complaints. So we used to have the complaints as section of the police force. So the question we're asking is, to what extent will this subsection achieve the objectives of the subsection? It is my opinion that this is just like MAZI AFAM OSIGWE pointed out, is a very poorly drafted, not well thought out, because a policeman is being sent to a police station, although he's a lawyer, to go and monitor, to go and advise his colleagues. Today, we see issues of violation of human rights, even in the state CID. Remember that every OC legal is usually, he has his office just at the state CID, most of the commands. So the question is that if the OC legal and all the lawyers in the department, the legal department of the state CID, have not been able to check issues relating to violation of human rights, detention beyond 48 hours, abuse of human rights, issues relating to liberty, observance of all provisions of law relating to liberty of the suspect or the detainee. To what extent do we think that posting a lawyer or a policeman who is a lawyer to a police station would achieve this? Now, if the act had provided that a lawyer should be attached to a police station, that would have been better, okay? Because anybody that would be able to monitor and advise the police should be independent of the police. He shouldn't be under the control of the police, because if he posts anybody who is junior in rank, of course, you know, police is a military organization or a paramilitary organization. So when you post anybody who is a junior in rank, if the DPO, for example, is on the rank of SP or CSP, and you are posting an SP who is a lawyer to go and stay at the police station, the first thing he has is to be obedient to his masters. So he might not be able to do that job effectively. That's number one. Number two, posting only one person who is a legal practitioner to the police station is not sufficient to achieve the objectives of posting the person there. So I don't think that will do much towards achieving the objective of protection of the human rights of detainees or suspects at the police station. So I think there is need for an amendment, an urgent amendment of that section to provide that station not be a police officer. I think it should be an independent body that is there to take care of issues of human rights, to advise the police, so that they will be able to, where they render the advice and the police do not listen, they will be able to make reports, appropriate reports, like to National Human Rights Commission about issues of violation that they have observed. If you place a police officer there, he wouldn't do things that might amount to indiscipline within the police force. And even if he says, okay, let me do things because this is in line with the Constitution, he might be subject to other aspects of victimization, being an employee of the police force. He might be seen as somebody who is trying to do IT care. That's I too know. He's like trying to expose the police force to ridicule to the general public. So that is why that provision that says that the person must be, the lawyer must be a police officer is not adequate. That is why my suggestion on that. Then second aspect, the second thing I want to say about that is that it shouldn't be only one lawyer that is posted to a police station. If we want issues of human rights to be properly monitored and followed up at the police station, there is need to post more than one lawyer to the police station. So the person must be independent, and then one person would not be enough because so many cases are being dealt with at the police station at a time. Then going to section 38, subsection 1 of the Act. Section 38, I would like to say a word on section 38 because this had been reoccurring. This had been there in several other laws. The CPC has the same provision. The CPCL has that provision. The CPL has the provision. The ACJL has it. The ACJL of Lagos 2011 has it. The ACJA of 2015 has the same provision. Now, there is a question that arises when we look at section 38, subsection 1. A police officer may, without an order of court and without a warrant, arrest a suspect, A, whom he suspects on reasonable grounds, of having committed an offense against a law in Nigeria or against the law of any other country. Now, the question is, how do we define whom he suspects upon reasonable grounds? You know, what we're trying to say that the policeman, of course, his reasons for arresting a suspect must not be subjective. Now, who will determine the reasonableness or the reasonable ground before the policeman can arrest? If you can arrest someone upon reasonable grounds of having committed some offense, how do we determine the reasonable ground? So that I suggest that, I submit that this has given the police the leeway to violate human rights, because this has made it possible for the policeman to tell you, oh, I suspected that he had committed an offense, even though, of course, if a person is found out later not to have committed any offense, the policeman will tell, okay, from the way he behaved, I suspected he had committed an offense. Upon reasonable, I had reasonable grounds to suspect that he had committed an offense. So this has made it possible. Okay, it has given the police a wider power that might maybe be liable to be abused by the police. So I think that provision needs to be amended to define specifically the conditions or the terms upon which a policeman may arrest without a court order and without a warrant. Another one is the paragraph B of section 38, subsection 1, that talks about obstructing a police officer. It talks about the police officer being able to arrest without a court order and without a warrant anyone who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody. Now, while attempt to escape and who has escaped, these are very clear. The question now that arises is, what is the meaning of the expression or the word obstruction? This has generated a lot of debate in so many platforms. Okay, the question now is, how do we define obstruction? I've searched through the police, Nigerian Police Force Establishment Act 2020. I cannot see any section, even the interpretation section, that try to express or define or interpret the meaning of the term obstruction. That means that the policeman now might decide on his own volition that, oh, this person is obstructing the performance of my duty, and he will take that person into custody by way of arrest. I think that the Police Act 2020 needs to make provisions as to what it means by obstructing. We need to now begin to go through other laws, including foreign and the law dictionaries and foreign legislation, to find out the meaning of the word obstruction. So there is need, if you say you can arrest someone for obstruction, there is need to provide for what is called obstruction, because my own research on what might amount to obstruction actually gives a very wide interpretation, which is liable to be abused. For example, obstruction does not necessarily mean somebody who tries to stop the police. For example, if a policeman invites you to the police station upon maybe during the time of investigation of a criminal offense, an alleged criminal offense, and you refuse to come, he might interpret that to mean an obstruction. Okay, so anybody who fights the police officer or resists arrest might be interpreted to have obstructed the police officer in the lawful performance of his duty. So I think there is need to delimit the scope of the word or the term obstruction, so that it will be very clear what they meant by that. Then I would like to point out, talk on the provisions of section 35 of the Constitution. Of course, the Police Act, like my big brother, Mr. KUNLE Edu, has pointed out that the Police Act has made it optional for a suspect to be with a lawyer at the time his statement is being taken at the police station. With due respect, sir, I would like to suggest that I think why the Police Act actually limits itself, left it at that optional angle, is because this Constitution does not make it mandatory that the lawyer must be with a suspect at the police station. So if I may be permitted to point out the provisions of section 35, subsection 2. Section 35, subsection 2 of the Constitution of the Federal Republic of Nigeria. It says, any person who is arrested or detained shall have the right to remain silent or avoid answering any questions until after consultation with a legal practitioner or any other person of his own choice. So what the Constitution has done is to give you the right, okay, to choose not to talk or to remain silent until you have consulted a lawyer. The Constitution did not say that you must consult a lawyer before you talk. So I think that that provision in the Police Act that talks about, makes it optional to be with a lawyer when your statement is being taken, is properly drafted. It might not be an aspect that we need to criticize, because if they have to make it mandatory, it will be in direct conflict with provisions of section 35, subsection 2 of the Constitution. Because section 35, subsection 2 does not say that when you are arrested or detained, you must have the service, they must call a lawyer. You may choose not to call a lawyer. It depends on you. It is your right. You may say, I don't want to say anything. But if you elect to say something, if you elect to make a statement in the absence of a lawyer, that does not amount to any violation of your fundamental human rights. So I think I approve of that provision that talks about, makes it optional, that you have to be with a lawyer before a statement is made. Although I would advocate in support of KUNLE EDU that provision should be amended, but the amendment must come from the source. Because if you make it mandatory in the Police Act, that will be in direct conflict with the Constitution, because the Constitution does not make it mandatory. It gives you a right. It is left for you to exercise your right or to choose not to exercise it. So if a suspect chooses to be with a lawyer or to consult a lawyer before making a statement, it is left for him. If he decides not to do that, nobody can force him to do that. And the fact that he was not with a lawyer when he made a statement does not amount to a violation of fundamental human rights, provided that the other provisions of laws relating to taking of his statement, including the judge's rules and other things, are observed. So I think I have to stop at this point. I don't know whether I have already exceeded my 10 minutes, because I was warned that I have to speak for only 10 minutes. Thank you very much.
Okay, what I would like to add to what we've said so far, and is what's happened with this Police Act is not new in Nigeria. If you look at the Land Use Act, for instance, it's a very fundamental law in relation to our country. It deals with land. It's a very defective law. Sadly, for over 40 years, that law still remains a major law in Nigeria. I would just want to commend to us that rather than see the glass as half full, half empty, let's see it as half full. And so we can really emphasize the useful provisions in this act. Because what's happened to us is not new, it's a failure of the fact that we really don't engage with legal, we do not really, what's the name of the body now? We're meant to have a body that's meant to really look at our laws and see what's absent and what we need.
Law Reform Commission.
Law Reform Commission, thank you. UDEMEZUE knows how obsessive I am with the Law Reform Commission. We shouldn't just go, and if, well, also maybe at the risk of insulting people, who do we have drafting our laws at the National Assembly? Are they people that should really be drafting our laws? And what impact does the NBA have with our laws? One of the things I would like to point out some very useful provisions in this law. A particular one, because I'm a feminist, is the one that actually provides, wherever the police needs to have intrusive search of a person, it must be by a police officer of the same sex. That should be commended. Then also, one that we know that has always been a major feature of our country, you get policemen to arrest people in purely commercial and civil cases. That's one of the worst violations of human rights. Now we have section 30, I think section 36, sorry, that says now you cannot use the police to arrest somebody for a breach of contract. Section 32, subsection 2. Like if something is purely civil, let it remain civil. Do not get the police involved. That is good. Also, section 35 is also good. You can't arrest Paul for Peter's offense. In the past, we've known parents who have been arrested for their children's crime. Also, the other one I really liked in this act is that a police officer can also lawfully disobey unlawful orders. That's in section 137. And for us to really make sense of these laws, a lot will depend on us lawyers. UDEMEZUE pointed something out earlier today, which I found really shocking. That a particular state in the country has been without a chief justice for so long. Because what stops the NBA or lawyers from actually applying with a writ to have the governor perform his duties? So there are useful sections here that we can actually deploy to make the situation better. So that I don't want us to now see the glass as half empty. Let's see it as half full. Let's look through these acts and try and use, to the point of exhaustion, positive sections that can make life better in our country. So I'll yield.
Thank you very much. Can I make a quick comment, Mr. Daniel?
Go ahead, sir.
Thank you very much. Just to make reference to what my friend Sylvester said with regards to the mandatory nature or otherwise of procuring a lawyer for the suspect, I actually relied on a judicial authority by the Court of Appeal, Lagos, when it interpreted similar provision to be mandatory. And that is the case of Joseph Zia against the people of Lagos State. The citation, of course, I will furnish you later. My Lord, now of the Supreme Court, S.C. Oseji, then Jesse Hay, had this to say. When, my Lord, when the Court of Appeal was interpreting the provision of Section 93 of the Actual Criminal Justice Law of Lagos State, which is similar with the provision that we are talking about, Section 32, 1 of the Police Act 2020. And my Lord had this to say. Section 93 of the law is mandatory as far as voluntary confessions are concerned, and non-compliance with the said provisions renders such confessional statement impotent. What am I saying? I am saying that if the law, the law has stated that when a suspect is going to make a statement, either the lawyer, his relation, or any other person of his choice must be there. These are the options. Now, the Court of Appeal interpreted those options to be mandatory, that the police has no discretion, that anytime statement is being made, give the suspect that right. But you and I know very well that in terms of practice, it is never done. Most of the statements, cautionary statements that we have in court, written in court nowadays, they are actually written by the IPOs, not even by the suspects. So what are we talking about? So we need to be very, very proactive and innovative, because if we don't put a stop to all this, we will continue to be having innocent persons being in the presence. And a lot of them are still there based on this very, very wicked provision. And I think it calls for further amendment, or better still, I will urge the judiciary, our courts, particularly the high courts, to be to apply judicial activism when interpreting these provisions. Anytime a confessional statement is being tendered, then make it mandatory that the suspect or the defendant must have given the opportunity to consult his lawyer, his relation, or any person of his choice. So I think it should be made mandatory, and the courts should come in to help us in this regard. So thank you very much. Sly.
Thank you so much for your submission. And like we know here, after every submission, questions come up. We have AFAM OSIGWE's hands up. Are you ready?
Quickly say that the problem we have with some of the provisions of this act, and indeed the Additional Criminal Justice Act, has shifted to the issue of judicial interpretation. Now we're talking about as what they call the Miranda rights in the United States. That means what Section 35(2) of this Police Act seeks to achieve, which is also the provision, has a requisite provision in the ACJA, is about the police informing a suspect of his rights. Unfortunately, there are conflicting decisions of the Court of Appeal. There were initial laudable decisions of the Court of Appeal Lagos Division that says that may, as contained in that section, means is mandatory, should be read to be shall. Unfortunately, the Court of Appeal Abuja Division departed from those decisions and said that may, as used there, is advisory, that they are not mandatory, that those sections are mere ideals which the society intends to achieve. I do not agree with those decisions, but in line with what we call now the most recent decision is that of the Court of Appeal decision in Abuja, which came later, supersedes or represents the position of the law. You can't tell me that the failure of the police to read the rights of a suspect to him or her should be considered as an ideal. It should be a mandatory thing. You should tell the person his right, in fact that he doesn't have to say. And it is in these provisions it gives effect to constitutional provision as also contained in Section 35 that a person charged may have the right to remain silent. Many persons who are brought before police stations do not know that they have the right to remain silent. And in fact, most times, the allegation that the police threaten to kill them if they refuse to sign, they make statements or sign statements made for them. The presence of law, therefore, makes a whole lot of difference. So it is for the judiciary to give seat to these provisions so that persons who find themselves in such situations are not thereby bamboozled into making statements or even being tortured, because also requesting the presence of a lawyer also not only makes the facts known that the person is there, but also puts him in a situation where he can calmly state his own style of the story without a lawyer interfering with the process. So I think it's very, very important that there be a final and a definitive decision in this regard by the Supreme Court to put these conflicting decisions to rest and decided in such a manner as to protect and guarantee the right of persons who find themselves in such situation to be read their rights, as to the right to counsel, and as to the fact that they have a right to remain silent. Thank you.
Please, can I say a word on this? I'm sorry, moderator.
Okay, go ahead.
Should I go ahead?
Yes, you have the floor. You have the floor.
Okay, thank you very much. Thank you. MAZI, thank you very much, sir. I want us to draw a distinction between two things because we're mixing some things up. My friend, Mr. KUNLE, says it is mandatory that the accused person, the suspect must be given the opportunity of calling in a lawyer. This is not, I want us to understand that what Mr. KUNLE has said is different from a lawyer being present. So saying that it is different to give him the opportunity, it's not the same thing. So it is mandatory to give him the opportunity. It's not the same thing with saying that it is mandatory for a lawyer to be there. So in my opinion, the three of us are saying the same thing. I agree totally that it should be mandatory, that you will be given an opportunity, the suspect be given an opportunity of or be informed of his right to have the presence or consultation with a lawyer. But this is not the same thing with saying that a lawyer must be there. If you give him an opportunity of calling a lawyer, you may give someone an opportunity which he decides not to take. So I think what the Court of Appeal has said and what the courts have consistently said is that it is mandatory to inform him of his rights. If you inform him of his rights, you can't force him to exercise his rights. The right, having a legal practitioner present at the police station is a right. No one is compelled to exercise his right. All you can do is what Section 35 has said. Both Section 35 of the Police Act and Section 35 of the Constitution makes it clear. Any person that is arrested may choose not to speak until he has consulted a lawyer. Then the Police Act is saying that when you arrest someone, you must inform him. You should inform him of his right. I think that is consistent with what Constitution is saying. So let us draw a clear distinction between two things, and they are totally different. Being mandatory, compulsory, that you must inform him of his right, because like Master OSIGWE said, he might not know of the existence of those rights. So it becomes very important, very, very important that you should inform him. Look, suspect, you have so and so right, 1, 2, 3, 4. Please, if you choose to exercise those rights, it's left for you. That is mandatory. That should be mandatory. But whether we should not agree here to submit that it is mandatory that a lawyer should be there, I don't think that is what the law says, and the law does not envisage that. Let us take the trial of the Nigerian in America. The Nigerian man attempted terrorism in America. He had lawyers to defend him, but the man said, I want to represent myself. I don't want any lawyer. You can't force a lawyer on him, especially in view of Section 36, subsection 6C of the Constitution, which says that Section 6, Section 36 says that every person who is charged with a criminal offense shall be entitled to defend himself in person or by a legal practitioner of his choice. So if the man chooses not to call in the presence of a lawyer, that is for him.
All right, Mr.
So I think what we should take as mandatory is that he must be informed, he must be given the opportunity. I agree with that. Right. But if we say a lawyer must be present, I don't think I agree, with due respect. Thank you very much, sir.
And we have more hands right here. We see Olashukwu Olaibi. Olashukwu, are you with us? Hello.
Hello, can you hear me now?
Okay, unmute yourself, Olashukwu. I sent you a request to unmute so that you can ask your questions or make your submission.
Okay, can you hear me now?
Thank you so much.
Yes, can you hear me now?
Yes, yes, we can hear you.
You can? Oh, good, thank you. Very well. I've listened to your deliberations and very quickly, what I would like to say, while I agree with many things you've said, the participation of the NBA becomes an imperative in many areas. Firstly, at the assembly, the National Assembly in particular, and then the state assemblies by extension, the NBA needs a presence. The NBA needs to monitor the process, not just the process of crafting our laws, but the contents of the laws, so that we will be advised. We will know precisely what is happening in those places, and red flags can be raised. In that way, many of these funny laws will not catch us unawares. We've said this many times, but there is no institutionalization of such a process. That is one. Secondly, many laws like somebody mentioned the Land Use Act. With due respect, the Land Use Act is the foremost law in furtherance of ease of doing business. The problem is with the operators of the law who have chosen to operate it in breach. I personally did a memo when Professor Shibajo was and I did an advisory on how they could deal with the matter. They took my advisory, and precisely what I cautioned against is what they now use to promote the so-called alpha beta till today. It's just the people who have been operating it in the breach, and the NBA needs to engage more proactively. That is an imperative. Thank you, gentlemen.
If I may quickly come in here, please. Much has been said about this law being poorly drafted and all whatnot. And no less a person that MAZI from OSIGWE appeared to suggest that many lawyers, or indeed the Nigerian public, are not aware that this law is being enacted until we suddenly heard that it had been signed into law by the president. My question is this an indictment of the Nigerian Bar Association, or is it an indictment of the civil society organizations, or is this an indictment on the Nigerian Ministry of Justice? I would like our discussants here who have been a former official of the Nigerian Bar Association and a present official of the Nigerian Bar Association. Let's start with MAZI from OSIGWE, please, and then we move on to Mr. KUNLE EDUN.
Thanks, Dan. Dan, I wouldn't want to apportion blame, but I think we all have a part of the blame. But the lion's share of the blame should go to the legislature. I'll tell you a quick story. A few years ago, I was part of the NBA team that appeared at a public hearing to amend the Court of Appeal Act. Then JB Dowd was NBA president, and the NBA, while not opposing the move to amend the Court of Appeal Act to increase the number of justices, was of the view that the Court of Appeal had performed poorly considering the higher number of justices they had than when they had fewer justices. And the Attorney General then, who was also at that public hearing, said there were going to be consultations, and then the stakeholders would meet again in a public hearing. The next thing we heard was that that bill had been passed into law and signed by the President of the Federal Republic. No further thing was heard about discussion. We all woke up during the lockdown to hear that the Company and Allied Matters Act had been signed into law. I do not know how many people knew that the bill was up for discussion after it couldn't be passed during the 2011-2015 legislative session of the Senate. The same thing we woke up to see that the Police Act had been passed into law. It would have been a different thing if this bill was shared among stakeholders for their inputs, whether there were public hearings or not. But you don't get that. You wake up these days to hear that a law has been rushed through the 3 stages of lawmaking, and even your legislator cannot even tell you anything about the law. So there's a lot of secrecy or opacity surrounding the lawmaking process in Nigeria. And the allegations that some laws are a product of pay to play, I may not be able to substantiate that, but sometimes you can't help wondering whether this may not be true, considering that once it suits certain interests, some bills are suddenly become laws without you knowing anything about them. The Nigerian Bar Association, no doubt, could do more to have a legislative advocacy group that is very active, that is able to have a hands-on approach and get all bills that are passing through the legislature, have inputs in them. Same thing should go for the branches in the various states of the Federation. But the reality is that NBA has not been living up to expectation in this regard. And in civil society too, sometimes so you can't even attend this public hearing because they tell you that you are not invited, your name is not on their list of those invited. And sometimes these public hearings are just seem to be held just for the heck of it. Nobody seems to take note of the outcome of these public hearings or the contributions made at these public hearings. And sometimes the bills people go to make contributions to never see the light of the day. So there's a whole lot to be said about our lawmaking process, and that is why a bill that is barely a few weeks old already has so many sections of it struck down by the Court of Appeal, because they failed to see that there are clear provisions in the Constitution that vested those powers in the Police Service Commission, and yet the Police Act 2020 sought to vest those powers in the Inspector General of Police, and also to repeat provisions of either the Constitution or the existing laws. And some of the provisions that we are saying are laudable, to me are not laudable. There's nothing innovative about them, because they're also products of so many judicial decisions that make it clear that you cannot arrest another person by proxy. You can't pick my wife because you're looking for me. You cannot pick me because you're looking for my son. Even logic, common sense should tell us that we don't need to be providing for these things. When you're looking for a suspect, you arrest the person you're looking for. And a piece of legislation coming from us to focus on much more than this. And let me make a comment. Professor UDEMEZUE made a comment about amending the Constitution. We cannot keep amending our Constitution. The American Constitution is just a few articles, but there's a whole literature on rights of a suspect to remain silent, what can be done, the effect of failure to read a suspect's rights on the statement obtained in such a circumstance. They are product of judicial pronouncements, and nobody has suggested that the American Constitution be amended to specify all these things. No Constitution can provide for every conceivable situation. But if the Constitution has given the right to remain silent to a person, and the law says the police shall read him may read him that right should be held to be mandatory. It's a different thing whether he chooses to exercise that right or not. But we cannot overburden our laws. But then again, there is need for the National Assembly to put out bills that are pending before them, call for public discourse, and have well-drafted and well-researched laws, and also hear the different views of the different segments of society before passing them. So in a nutshell, it would not be right to say, oh, it is Mr. B's responsibility. For all of us have said we could do better, but the legislature will do best by being much more open and transparent in the lawmaking process. Thank you.
We thank you very much. I wonder whether KUNLE EDU has something to say on this issue about the Nigerian Bar Association and the lawmaking process.
Yeah, in addition to what AFAM has said, I can very well tell you that the NBA actually has its own challenges, but it is not true that whatever the National Assembly does with respect to passage of bills, whenever it comes to the attention of the NBA, I'm personally aware that we do set up some select committees to go through such bills and make our inputs and forward same to the National Assembly. But the question is, does the National Assembly actually consider the inputs, the opinion of the NBA? That we have seen that in most cases, the National Assembly doesn't. Now, we also are aware of what had just happened recently with regards to the purported amendments of the ROPC. Can you blame the NBA for that? You cannot. Because many of these laws are passed, without the knowledge of even members of the public, and much more the NBA. And unfortunately, we have our colleagues in the National Assembly. And like what my very good friend, my senior in the ESCO said, the first vice president, it's like when our colleagues get into the National Assembly, they start being lawyers and start being politicians. They forget that their first calling is the legal profession, and they have a right, a duty to the public. And that first duty is fundamental, but do they really do it? They don't. So you cannot really blame the NBA. But I can tell you as a matter of fact, that the present administration of Olumide Akpata, we have started well, and you can attest to that. By the next meeting, we are going to set up a lot of committees, and one of the committees will include this legislative advocacy group, because we are going to interface between they're going to be an interview between the NBA and the National Assembly, which has actually already started. Last week, the president had a visit to the office of the Speaker of the House of Rep, and of course, we're going to follow it up with the Senate president. So this engagement will continue, so that we don't have a situation where these will be passed into law without the knowledge of the NBA. And I can bet you we're going to improve on it. But certainly, all of us hold that responsibility, including you, including every one of us here, that whenever any bill is being passed, please, you can reach out to the MD through your chairman. You can even call us directly that this bill is being passed. Are we aware? You understand? Because it's very unfortunate because that we are still having it with ROPC. But I believe that at the end of the day, it will be resolved. So by and large, the NBA presently constituted would not disappoint Nigerians, would not disappoint lawyers. We assure you that any bill that will be passed henceforth the NBA will monitor the bill and also make inputs to same. Thank you very much.
I think I like what AFAM said regarding the American Constitution. It's not a very big document, but it has gone through centuries of judicial activism. I think the attitude in Nigeria is that we tend to really want to really rely on the benevolence of the people that we're meant to really supervise and have oversight over. Nothing stops the NBA from actually using the Freedom of Information Act to call for all the present bills going through the National Assembly. And the NBA can have its section of practitioners who will come through these bills and see what alternative provisions they can make. If you look at the police force in Nigeria is a creation of the Constitution, Section 214. We don't have to wait for the Police Act before we start reacting. We're being reactive. If you look at 214, it says the police force shall be created. It's a constitutional creation. And that being the case, is a very important body for the running of public order in Nigeria. We shouldn't wait until when these guys just spring laws on us. Let's collect whatever bill using the FOI to know what is in place. And also, secondly, we need to involve more of this item of legislation in the courts and have less of all this election material, election petition clogs our courts. Election petitions are not really furthering our judicial development. These are the things that will really improve lives in Nigeria, testing the limits of Police Act, Land Use Act, not petition. So NBA should please apply the FOI, call for all present bills in the National Assembly and get our practitioners to look at them. Thank you.
Thank you so much. Do we still have Bethel right here with us?
Thank you very much for the opportunity. Yeah, just want to make three quick comments. Let me go back to the issue of 35-2. It's been argued too much, but I think, hello?
We can hear you.
Okay, I think that, okay. I think we are making a mistake here. The right to be entitled to a lawyer is already a constitutional provision. If you look at this Police Act, notice a lot of things they try to bring back things that are already in the Constitution. But what they actually did was to reduce those rights. Just what they did in Section 35, they took away that right from the back door. What that law should have said is that every suspect shall be entitled. If you are entitled, you cannot decide to exercise that right or not. But the way it is put now, it is now the police giving you that right, giving you, it becomes a privilege. So I do not agree with UDEMEZUE's provision. Is a right for you, a choice. No, you are entitled to it. It's a right for you. You cannot decide to exercise it or not. In as much as they decide to put it in the bill, sorry, in the act, that is how it should be. It should be. However, they actually need to put it in the act, but it's already a constitutional provision. What they did here was to reduce that right. One. Second, with the issue of the audiovisual recording of confession and statements in police, I think it should be made compulsory. It's no longer an issue of right, because one can come on tomorrow to deny that that's a statement, and one can, the police might, people are alleging that this happens in police station. People are beaten up, people are harassed, people are intimidated to make confessions which they do not, which is actually not what happened. So it should be made. The provision there should state that, because that has not been taken care of in the Constitution. So it should be stated there. And it is composed. There should be an audio, not just audio record, audio visual record. So we will see what is happening, and we'll hear what the suspect or the accused person is saying, and know how he or she is being treated, why he or she is under interrogation. So next thing I think I need to report, and somebody has already said it here, but let me just emphasize it: the issue of participation of the NBA in the law-making process. I know the NBA has lots of committees dealing with different areas, businesses, human rights, so many areas of law. They have the NBA committees on this. Those committees should be involved in the lawmaking. They will have a public hearing process in the National Assembly. You have a right to attend. You have a right to attend. The NBA is a formal stakeholder in the lawmaking process. So in fact, they don't even need an FOI to be aware of what is happening. They have just go to the National Assembly and get the bills that are already in progress and know when the public hearing is being scheduled. Most of these public hearings are announced. For the ones that are not announced, they can ask why are they not announced. The NBA should be there. So all this rehashing we are doing after the fact, it doesn't help matters. We should have been involved in this thing before they come into law. That's one thing I wanted to mention. There's this also this issue that I think one of the hello.
Go ahead.
We can hear you.
Hello. Okay, thank you
Hello.
very much. I'm not sure anybody has mentioned it. The issue of hello. Can I go ahead?
Yes,
Hello?
sure.
Okay, thank you very much. I've forgotten the particular provision that talks about the police having to report to the magistrate about the number of persons that have been arrested or detained over a night in the police station. But that provision appears to be, I don't know, should I say incorrect or what? Because it stops us reporting. After reporting, what happens? What's the right of the magistrate? What can he or she do? Will know what he or she should do after the reporting to call for the record somebody. And I agree with him. 48 hours is too long. You bring somebody, you've already breached the person's right based on your suspicion. Before you can know he's taking fingerprint, before you can have something to report to the magistrate, this is too long a period. This thing should be done as soon as the person is, after all, before you went about arresting the person, you knew who he or she was. Or if you are arrested in the course of committing a crime, you would have asked him or her his names. So that should be the first thing to do. As soon as you come in, put those things in record and submit to the magistrate. And in fact, there's even no need for you to go to the magistrate's office to submit those records. It should be shown on the magistrate's, there should be a desk officer in the magistracy seeing those records. But these are things we should look at. Provisions of the chapter 4 of
the issue of the moment is now the end SARS protest. And now the federal government has ceded to the demands of the protesters. And now we moved on to the end SWAT. And now we don't even know whether it's just about end SWAT anymore, whether a lot of other things that needs to be changed. But then what started the entire process was end SARS. The issue of police brutality has been a long standing problem as far as we could remember. My question to our discussants tonight will be, will this new police act now, to what extent has it addressed the issue of police brutality? And do you think even in the areas where it addressed the issue of brutality, whether that will be the solution to the problem? Do we have a particular sections of this act that address the issue of police brutality? If there are, how effective will they be? And what is your general view about police brutality in general in the country?
I'll say Section 133, which established the Public Complaints Response Unit, will have been a very brilliant one, in that it allows members of the public to bring complaints against any police officer. Sadly, the composition of that body is not an independent one. All its members are police officers. It's as much as you trying to present a case and you being the judge over the case you're presenting. So if that particular section can be urgently amended, I think that would be a very good one for Nigerians. And if that body is one that the NBA and other stakeholders put under the spotlight 24/7, and if any police officer can be brought there and any charge is brought against them, that will be a groundbreaking one. Unfortunately, I don't think the policemen will get against their own.
We thank you. Do you have any other contributor to this issue?
I don't know if I may say a word on this.
Yes, of course.
Okay.
Okay. The issue of police brutality, goes straight to part of what I had pointed out earlier on how may the police arrest, but it deals squarely on treatment of an arrested person. That's exactly the aspect that deals with police brutality. I agree totally with Mr. OLAITAN on the defects of the provisions of Section 132 and 133 of the Nigerian Police Force Establishment Act 2020. It's not an independent body, and it is going to be very difficult because the X squad had been there. It's just like the X squad, the department that had been dealing with complaints against police officers. But the problem with this section is that it is a section that comes in after someone had been brutalized. No, the question now becomes, how do we prevent a situation that would even lead to brutalization in the first place? Because the only person that makes a complaint is someone that is saying, my right has been violated. In other words, violation of right may have been concluded. The person may have been killed. Someone may have lost his life before the issue of complaint to the police complaints response unit arises. So I think the more important question should be directed at how do we prevent this brutalization by the police? And I think this is what one of the major reasons, one of the so many reasons that led to the current protest by youth, because it arose over, it had built up over so many years, you know, that so many videos going online, going all over the place of people tolerating brutalization by police and other law enforcement agents. I think the Constitution takes care of it. The problem we have, like MAZI, AFAM, OSIGWE pointed out, is not with the laws, okay? Our laws have their defects, but the problem we have is our attitude to these laws. That is exactly what led to this NSAS debacle. Because if our police officers had been well educated on the provisions of the Constitution, on how to treat arrested persons, there wouldn't be any problem. Section 34 of the Constitution, for example, talks about the right to dignity of the human person. Okay? The right to dignity of the human person. Every individual is entitled to respect to his dignity, to the dignity of his human person, and accordingly, no person shall be subjected to torture or to inhuman or degrading treatment. No person shall be held in slavery or servitude. No person shall be required to perform forced or compulsory labor, and so on and so forth. So I think Section 34, subsection 1 of the Constitution makes it very clear. And that is what points to the root of police brutality. So brutality is all about violation of Section 34, subsection 1 of the Constitution. When you treat someone in a manner that does not befit a human being, the way they treat animals, you are actually violating Section 34. The question now becomes, how many police officers are aware of the provisions of Section 34, subsection 1 of the Constitution, forbidding treating anybody, subjecting anybody to torture or other inhuman or degrading treatment? Most of them are not aware. So I think the police force need some kind of reorientation. They need some kind of reorientation. There is need for every policeman to undergo some course on these rudiments of practice. There's need for a code like the RPC, and every police officer should be examined on that code, whether you went to school or not. There should be training and retraining on this code, on how to observe them. Because our problem is not about our laws. This provision alone is enough for a policeman to know that he is not supposed to treat anybody in a manner that is inhuman. Because the person he's treating this way is another person's child. And he has his own children. He goes home to his house and then takes care of his children. If there's any scratch on the body, he takes them to the hospital. But he goes out mistreating other people's children. Okay, especially when you look at Section 36 of Section 5 of the Constitution and similar provisions in the African Charter and the Universal UN Declaration of Human Rights that talks about an accused person being presumed innocent. If a person is presumed innocent, the implication of that is that he must not undergo any form of punishment unless and until he has been convicted by a court of law. So even if you think that he had done something wrong, even if you caught him red-handed, even if you saw him in the act, you must not subject him to any form of punishment until he has been confirmed guilty by a court of law. I think that is what goes to the root of this. So orientation, education, and orientation and education is what the police would need, what police need to be able to get abreast of these provisions and be able to keep them. The problem is not about the laws, because the laws are there. If Section 34 says you cannot treat anybody in an inhuman or give anybody inhuman or degrading treatment, and Section 36 Section 5 says he is presumed innocent, in which case he must not be punished and must not be subjected to any form of torture or punishment until his guilt is confirmed. And this has been upheld by so many judicial decisions, both by the Court of Appeal and the Supreme Court. Okay? Amechi and INEC, for example, makes it very clear that a Nigerian must not be made to suffer any form of punishment, any form of deprivation, unless and until a court of law has pronounced him guilty of an offense. So police brutalization and torture and victimization of suspects are just inhuman treatment being meted out to people out of their own ignorance. But even the police officers who know about these things still go ahead to do the same thing because of the nature of the police. I think there are so many factors that give rise to that. I will say something that will make us laugh. A visitor to my house, coming to my house, we were watching the television and the guy saw where someone was a kind of talking anyhow, talking somehow, uttering crude words. And the gentleman told me, Mr. UDEMEZUE, the way a person speaks in the day, during the day, is actually determined by where the person slept at night. You know, the way someone behaves during the day is determined by where the person slept at night. Now, look at the police barracks across the country. They look like we are people that are less than human beings sleep. If you go to any police barrack in Nigeria, you will pity the police officers. If a person sleeps in a police barracks with that kind of condition, when he comes out in the morning, he behaves like an animal. So I think the attitude of our government to the police is a principal factor in the behavior of the police towards the masses. So that is why the protesters are also calling for increase in police salaries, total reform of the police, better welfare for police officers. So the protests are not necessarily against the police officers. They are also fighting for the police officers. If you fight for them and they have better condition of service, they would also treat us as human beings. As long as the policemen are subjected to inhuman and degrading treatment, because the government of this country, the government of the various states are subjecting the policemen to inhuman and degrading treatment. As long as this persists, policemen also might continue to meet this, unleash their frustrations on innocent Nigerians, leading to violation of constitutional provisions on respect for human rights. Thank you very much.
Okay, thank you. If you quickly call on KUNLE EDUN, please, to...
I don't know how you're going to do it. You want, the laws are fantastic. There's no problem with the laws. But how are you going to do it when you are paying a sergeant 60,000 naira and you expect the sergeant not to cut corners, not to violate the rights of suspect detainees, or just to get some money? I'm not holding brief for Nigeria Police Force, but like what Sly said, there are a lot of issues regarding their welfare. Now, I put some of the blame at the doorstep of the judiciary. The same Police Act, the same ACJL and ACJL have made provisions for the setting up of monitoring committees by the chief judges of the various states or the federation. The same Police Act and the ACJ and ACJL have also made provisions for the magistrates to visit detention centers. Why is it that the magistrates, the chief judges, have refused to invoke these their powers and do the needful? About 8 months ago, I wrote a letter in this regard to the chief judge of Delta State. I cited these provisions, requesting that the states, that the chief judge should set up the monitoring committee for the state so that we could visit the various detention centers. The letter was acknowledged. I didn't get any response. I sent a reminder. I didn't get any response. But the good thing is that the Olumide administration, we are going to insist, we are going to meet with the various chief judges. Actually, we have started with a meeting with the CJN so that these provisions in the new Police Act and the SCJ and SCJL will be invoked so that the necessary these committees will be set up, will be set up so that the NBA and particularly the branches, the chairmen and leaders of the branches will not be undertaking periodic visits to the various detention centers. And I think if we can start with that, we want to, in a substantial way, check the excesses of the police. Of course, reports will be produced. And like what one of the commentators said, what happens after reports have been produced? Certainly, there will be recommendations. Certainly, there will be indictments. So I think the judiciary has a very, very big role to play here. If the judiciary does its part by setting up this monitoring committee and making the appropriate recommendations, and the policemen knowing very well that every month these committees will be coming to visit, they will sit up. They will sit up. But that does not remove from the fact that the welfare of the average policeman needs to be well taken care of. My brother, these guys, they are terrible. They are really terrible. And they are hungry. And you are giving them guns to, it's terrible.
Emeka Ibe, please.
Yeah, good evening, gentlemen. Can you hear me?
Yes.
Okay. I'm based here in Lagos, and I've been practicing law for over 2 decades now. Now, I want us to do something, or rather, I want us to pay very close attention to something. Whenever we are discussing police issues, we should not just base it on legislation, on the laws, what the law says. My brother, there is a great deficit. There is a terrible deficit. over what the law says and what the police people do in their police stations and police formations. There is a very simple reason for this. Sly UDEMEZUE pointed this out when he made his last comment. There is so much ignorance. I don't want to talk about the other welfare issues that the police suffer. Yes, their salaries, their welfare, their accommodation and things like that. But what about the knowledge, the basic knowledge that the policeman is supposed to possess in order to do his work effectively? Believe me, this is lacking entirely. You see, a policeman has a sobriquet, he has another name. His name is also a law enforcement agent. Law enforcement agent. It points to a policeman or any other agent of any other security agency. It presupposes that for you to be a law enforcement agent, you are supposed to know the law that you are supposed to enforce. But what do we have? In 2004, here at the Ikeja Police College, I was privileged to be in the midst of police cadets that were being trained. They were being given lessons on criminal law and evidence. It is actually part of their training. I was sitting in their midst. Now, would you believe that the person that was giving them this lecture was not even a lawyer? He was teaching police cadets evidence and criminal law. And this person was not even speaking good, he couldn't even speak good English. So what did I do? When I started hearing the things I was hearing there that were off the statutes entirely, I had to raise up my hand. I said, sir, would you mind if I assist you? Of course, they all knew me because I was invited there because of who I am. So he was very happy. He handed me over the class. And what did I do? I started from the first page. I told them that we have to recall everything that had been said already. Let's start afresh. Because I realized that the handout that this gentleman was using was written sometime in 1971 or 1972. It was based on the Evidence Act of 1911 or so. So I had to handle these two classes. After giving them lessons on evidence, I started the next class. I had to waste my time to give them another lesson on criminal law. Then what did I do again? I took those two handouts back to my office. I went and did a comprehensive overview of what they intended to say in that handout and what the current laws had to say on them. And I went and presented it to the then Commissioner of Police. In fact, they gave me an award because it is that handout, I can tell you, that they are still using there now. Meanwhile, we now have a new Evidence Act of 2011. I am sure the police are not aware. So the level of ignorance is debilitating. Through our colleagues who are police officers, they have OC legal in every police formation you go. What exactly do they do? Because these are trained lawyers, even though they are policemen, and they all behave like policemen. They don't actually behave like lawyers. But if the MBA, as some people have suggested, some colleagues have suggested that the MBA can always come in to assist all these agencies, because we are doing it for the society. We are not doing it because it's just the police. We are doing it because of the impact it will have on our citizens and the society at large. If we cannot do all these things at this level, believe you me, no matter the kind of legislation we put up, nothing will change. Mr. UDEMEZUE was trying to differentiate between the difference between having your lawyer present and all that. But my brother, that is not even the issue. The issue is supposed to be, what chance does a suspect in a police formation have to know that, to even know that he or she must elect to make a statement first before a statement could be taken. It is totally absent. The police threaten you. If this, I have a client at EFCC who was beaten for 7 days and locked up in a dungeon just because he refused to write a statement. EFCC, it happened. My own client. So if the police will not even give you the space to exercise your constitutional right to keep silent, to remain silent, what chance do you as an ordinary citizen have before them? That is why it is necessary that a lawyer must be available. Because if a lawyer is present, the police cannot force you to make a statement. So let us always balance these things with what happens practically in police formations and what our laws are saying.
Well, thank you.
If we follow legislations are saying, nothing will be achieved at the end of the day. Let me stop at that. Thank you for.
We thank you very much. In fact, we would like to have another discussion with you another day on police conduct. But meanwhile, let's have Engineer Ifeanyi Anagu, please. Engineer Anagu, please, if you can unmute yourself.
Thank you very much, Daniel. Can you hear me?
Yes.
Good evening, and good evening, the discussants and the other people in the meeting. I am not a lawyer, I'm an engineer, but I'm interested in the topic of today. And mine is not really to say much about the legal aspect because I'm not a lawyer, but I just want to make the following observations or contributions. Now we're talking about police reform, the Police Act, and the people are now protesting in Nigeria. And the government seems not to understand that one of the things that people are looking at is this issue of centralization of our police. There is nothing that will be done to get these things right if you don't decentralize police. You cannot be policing a whole country like Nigeria from one point. That is too bad.
So let's go on to Oluwaseun Aka, please, and then lastly, and then we go back to our discussions. Oluwaseun, please, if you can make a contribution.
Yes, good evening. Thank you very much, Mr. Daniel. My greetings to everyone in the house, the participants. I just want to lend my voice to to our discussion. One is as
we are not seeing you.
No, but can you hear me, sir, Mr. EDUN?
Yeah, we can hear you, but are you as ugly as I am? That you don't want us to see.
my organ,
that will hide your face.
my organ, I'm not hiding my face, but I think I'm okay by my voice. If you can hear me, I think I'm good to go. Yes.
Back, so continue.
I want to add to what we are saying. Number one is the fact that police, they do not know anything, but they believe that they know more than lawyers. That is one of the problems. May I quickly just share experience of what I had? At a point in time, I had cause to go to the police station with a client. And what was the offense? It was that my client bought a phone from somebody and the phone was not working. He sold the phone to somebody, and probably after 2 or 3 days, the phone was not working. The person had to bring it back. Then my client said, okay, wait, I'll give you after some days and things like that. The buyer actually went to the police station to report my client. When we got to the police station, I was asking the police officer that what's the problem. They said, my client has committed crime. I said, what is the crime? They said he's selling phone and he doesn't have license to sell phone. That is only people that can sell phone are people that have their shops. I was like, what is going on? What are you saying? So I was annoyed. I had to go to the DPO immediately because they were about to, malhandled him and things like that. But thank God that I was able to meet the DPO, and the DPO was like, what are they saying? So that's to show the caliber of people. What also shocked me that day, what shocked me was the kind of effrontery, the kind of confidence with which the police officers were saying what they were saying. That is only somebody. So I was even asking them, so if I'm tired of the phone I'm using, I can't sell it on my own. So that underscores the kind of police officers that we have. One other thing I want to add is, can there be legislation that every interaction that we have with police cannot always be recorded on phone? Because I know for a fact, in Lagos State, LASMA officers, for whatsoever, for gathering of evidence, probably when you are not using your seatbelt, or probably the traffic light issue, they always make use of their phone to record you and gather evidence. But when it comes to policing, you go to the police station, or in the case of SARS, they would never even allow you to make use of your phone. So if you are able to use your phone, I think there should be a legislation that whenever you have contact with police, you should be free to use your phone, so that whatever that is happening can be recorded in case of anything. Most often you see these boys, these SARS boys, they will accost you, they will check your phone, they will, when they check your balance and there's so much money there, they will ask you to make withdrawals. Most of them is so shameful, they have POS with them. And that is not coordinated into all this that we have. So my point is, I want a situation whereby an average person, whenever they have contact with the police and they feel that something might happen, it should be a law that they are entitled to make use of the phone. Phone should not be collected from them.
All right.
So if we have that type of legislation, it will boost our complaint against the police and other law enforcement again. Thank you very much.
We thank you very, very, very much, Mr. Oluwaseun, please, for your contributions. Now, I'm sure that our discussants have listened to some of the issues raised, and they may have some responses to give and then use it to give us their concluding comments on the topics we have discussed today and all the issues raised. So shall we start with Mr. Lighter? Can we start with you, please? Lighter.
Okay, well, thank you. Well, there's an elephant in the room, and I'm sure we have people on equal side of the divide, whether we should have state policing. I'm a proponent for state policing. Having a centralized police command in Nigeria will just replicate the inefficiency we have in our country. I know for a fact that Lagos State, as far back as 1981, was advocated for state policing. And even Lagos State has been having a pseudo-state police. They fund police, and if you look at Lagos State, it's relatively safe because what they pay the policemen there is quite considerable. And policemen are really ready to work. They buy cars for them, fuel, and pay them pension. But sadly to say, Section 214 of the Constitution prohibits any other police force in the country except the Nigerian police force. We're living a lie. If you go to Kaduna, if you go to Kano, you have the East Bar group already with pseudo police functions. We can't have a centralized police system. I'll leave that. But coming back to this act, what I want to suggest to us, as imperfect as it is, let's try and deploy the use of the positive sections in that act to try and improve the life of our people. And I will call on the NBA. The NBA should not keep being reactionary. The NBA should actually be at the forefront of law reform and execution, because there are quite a lot of laws in Nigeria that can make life better. It's just that we do not really give life to these laws. NBA have a lot to do. It's pointless printing things during the NBA conference, spending millions. Spend millions on legislative initiatives, be at the forefront of what they're doing at the National Assembly, and let's have a very important office that will monitor what police are doing. Thank you.
We thank you very, very, very much, Mr. EYIOWUAWI, for your contributions tonight. I don't know.
Oh, thank you for pronouncing my name very well.
I don't know whether I'm bothering your name, sir. I'm so sorry.
Did very well. I'll give you 90%.
All right, thank you. All right, Sylvester, please. What do you have to say with regards to some of the issues raised by the last commentators and then use it to give us your final take on the issues we have discussed tonight.
God bless you. The truth of the matter is that so many things have been raised and we have very limited time to discuss all. But I'm happy that many people were invited to speak on aspects of this. The police reforms, like Mr. OLAITAN had mentioned, is a very, very pressing thing in this country. Before we have the state police that many people have been clamoring for, there is need for us to do things right, to reform the police, to reform their attitude to the masses, to reform their attitude to the people that they were employed or paid to protect. Because the problem we have in this country is that the average Nigerian is much more afraid of the police than the armed robber. That's the problem we have. Some people even get killed, like the case of the lady, just about before the protest started. We are aware of the lady, the NYC, the core member that was murdered in police custody. She was arrested in place of another person, the real suspect, her boyfriend. And then the following day, she was dead. So these are the problems we have. If the citizens or the masses are no longer safe in the hands of the people that are being paid to protect them, we can't expect us not to be unhappy. And that is why you have seen the expression manifesting itself in the hands of our youths who are now on the streets protesting against police brutality. So I think that there are so many things that we need to talk about, but with very limited time to talk about them. I suggest that there is need, like I said earlier, and my Oga MAZI responded that there might not be any need for amendment in the Constitution. I want to draw our attention to the fact that the American Constitution is not actually the same thing with the Nigerian Constitution, because the Nigerian Constitution in section 1, subsection 3, makes it very clear and leaves no one in doubt when it says that if any other law is inconsistent with the provisions of this Constitution, the Constitution shall prevail, and that other law, to the extent of such inconsistency, will become void. If that is the case, where the Constitution has made a clear provision on making, for example, the presence of a lawyer at the police station optional, I mean, depending on the wish or the choice of the suspect, any law that tries to make it mandatory might not actually be held to be consistent with the provisions of the Constitution. So I agree with the position that there is need, like Mr. Emeka pointed out, there is need. If we leave the police to observe these provisions on their own, they would never do that. It's not possible. Like Mr. Emeka pointed out, their attitude is a different thing altogether. They don't think about the law. The question is, how many police officers can even read and write? We are not talking about that. I was traveling to Enugu from Lagos. I got stuck. I was stopped by the policemen. They were holding my car papers upside down, and they were asking me for auto reg. I don't know what's called auto reg. And I informed the police there's no document that is called auto reg. Auto reg simply means automatic registration. He said I must produce my auto reg before I would be allowed to go. That automatically means he didn't even know what he was holding in his hands. He was turning my paper, holding my papers upside down. So they don't even understand what they're doing. Some of them had their wire written by people just to meet that minimum qualification. So I suggest that we should amend our laws from the Constitution to make it, to upgrade it to the position that applies in capital offenses. The law in Nigeria is that any trial, any proceedings in a capital offense that happens in the absence of a legal practitioner is void. I think that should be extended to the police station. Any statement of a suspect taken in the absence of a legal practitioner should be held void. It shouldn't stop at informing them of their rights. It shouldn't stop at giving the accused person an opportunity of electing to have a lawyer present or to consult a lawyer. Because like Mr. Meka mentioned, and like MAZI also mentioned, it is not possible for police to observe these provisions. The laws are there. The law has said what we're going to do, but they don't observe them. So the best thing to do is let the laws be amended from the Constitution to make it mandatory that when a person is at a police station, no statement of his should be taken except in the presence of a lawyer. That will also help the lawyers in court, because if you get to our courts today, you see many criminal objections. Many people are objecting to confessional statements of accused persons. If that happens, when we know that the lawyer was there, it will not become difficult for a lawyer to go to court and put up a plenary objection. I have to stop here because there are so many things to be said, but I thank you for inviting me to this program, and I thank my colleagues and my organs for having me participate. God bless you. Thank you.
We thank you. MAZI OSIGWE, please, let's have your...
let me just say that I still do not agree with Sylvester, Prof, as I call him. Now, if you look at Section 1B of the Police Act 2020, it says that that the objective of the act is for certain of the police is based on the principle of protection of human rights and fundamental freedoms. What does this mean? This means that any act that imposes a duty on the police, like Section 35(2) of informing a person of his rights, should render any statement contained in violation of this duty inadmissible. It does not contradict the Constitution. I'm not arguing that a lawyer must mandatorily present. Otherwise, a suspect can use it to frustrate a fair investigation. But you must read him his rights, as they say in America. It is part of the due process of law. When you read him his rights and give him his options, he has a right to choose to exercise that option or not. Having read him his rights, you may, and he opts not to make a call. There's a provision in this act that police should also give him means of communication. It should be read together. So they should give him a right to make a phone call to a family member, to a lawyer, informing them he's there, and may not exercise the right to make a statement until they be present. Now again, there's need to water down the extent to which the police can arrest an individual without warrant upon reasonable suspicion, whatever that means, that he or she has committed an offense as contained in Section 36 or 38. This is why the power the police has abused so much. They see a young man with a dreadlocks, with tattoo, with an expensive car, and they said he's a Yahoo suspect. He's involved in cybercrime. The extent of this abuse has got to a point that we should make a law to require that the police must arrest people with a warrant, except where an offense is committed in their presence. Where it is not committed in their presence, then the power to arrest should not arise. This greatly abused power is what you see today in the EndSARS movement, because these people see you, they know they can arrest you because no law compels them to convince a judicial officer to authorize them to arrest you. And that's why they can extort money from you and even kill people without keeping records of their incarceration, or keep them for long periods without charging them to court. We need to amend the law. Also, the reporting ones about reporting to a magistrate. Why should the police wait for 1 month, the end of the month, before reporting to a magistrate? Why should it not be a weekly affair? So they can as well arrest a person from the beginning of the month and keep him to the end of the month before reporting. And the procedure provided in the Act about entitlement to bail should be clearly drafted in a clearer manner, as to make it clear that the right to bail has now been made either mandatory or otherwise, because it's drafted in such a vague manner as to indicate that what is given with one hand may be taken away with another hand. We should make this law work to better protect the rights and freedoms of the people. And the duties imposed on the police must be interpreted by the courts as being mandatory, so that any breach of them should render their actions void, or any statement or confession obtained in furtherance of that inadmissible. Thank you so very much for having this wonderful discourse, and I hope that some of the views expressed here will be found useful in building a better society where the police respect the rights of people, and the saying by the police that the police is your friend will one day be believed by people and be acted upon. Thank you very much.
On that note, the police is your friend, which I'm not sure any of the...
I'm not sure.
I'm not sure there is any of the demonstrators who agree that the police is their friend in this period. But thank you very much, Mother. It's been a very wonderful evening. Thank you all our discussants. Thank you, EYIOWUAWI, for being with us tonight. We know you are based in the United Kingdom, but we can now see that you are very well conversant with whatever happens in Nigeria, especially in the Nigerian legal system and policing. We thank you for being with us tonight.
Thank you.
Mr. Lighter is an expert in Nigerian law. He follows all trends.
To you, Professor Dems.
He's always with us every day.
Okay, and Mr. UDEMEZUE also, thank you very much for...
Thank you, Mr. Lighter.
Okay, Mr. UDEMEZUE, thank you also very much for being with us. It's been a wonderful evening, Mr. UDEMEZUE.
God bless you.
MAZI, MAZI OSIGWE, you've always been our friend. You always answer whenever we call. So thank you very much once again for being with us tonight.
Thank you very much. And excuse my dressing, I couldn't be formally dressed.
Well, that's formal enough for us tonight.
Thank you very much.
Oh, thank you very much, guys. And thank you, our contributors again, Emeka Ibe, engineer, and I'll go. I think the gentleman has left, but okay, thank you very much. KUNLE has an urgent call to leave prematurely. So we thank you all very, very much. In this time that we are having all these problems, let's hope the powers that be will take more care in making our policemen responsible. Thank you.
Thank you.